The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. We're here on a petition for writ of mandamus. State of New Mexico versus ex-rel Carl Reifsteck, Director of the Administrative Office of the Courts, versus Wayne Propst, Secretary of DFA. The council, please enter their appearance for the record. You reserve 20 minutes, 15 minutes?
15 minutes to start the fire.
Thank you. There's nothing further, council, you may begin.
May it please the court. Secretary of Finance and Administration has no authority to block an administrative order of this court governing judicial employees. Article 3, Section 1 of the state constitution forbids it, and the legislature has not even purported to authorize the DFA to exercise that function. In fact, DFA's involvement here is strictly a matter of administrative convenience. DFA houses the infrastructure to physically get state employees paid. But there are separate administrative apparatus for each branch of government. The AOC for the courts, Legislative Council Service for the legislature, and DFA for the executive. It just doesn't make any sense to have three share systems. And in this case, we're asking for a writ of mandamus because the Secretary of DFA unilaterally has blocked an order from this court adopting a paid time off system of leave since last June. In doing so, he's overstepped his bounds within the state constitution, and a writ of mandamus is the appropriate remedy. The PTO order was adopted by the court in May, and what it does is it shifts from a system of leave divided between sick leave, annual leave, and other types of leave into a unified leave system. It does that against a backdrop of each branch of government having widely divergent leave practices in a wide variety of areas, and the legislature having specifically stated that no state agency, even within the executive branch, is required to grant sick leave. Under this court's prior ruling,
The effect of the order, however, is that employees will get more money than is allowed by, I forget the section, 10.7, 10, and 10.11. And that's the crux of the conflict, correct?
That is the position the DFA took in order to block the order, acknowledging that there was appropriated money within the judicial budget to make the payments. And that determination involved looking past the court's order approving paid time off, which should have been granted deference, and determining instead if there's a direct conflict.
10.7.10, 10.7.11 place a general limit on the amount of money that can get paid to employees when they retire or otherwise for unused sick leave and annual leave. Then why wasn't DFA able in some way, they may not have gone about it correctly in this issue. It could be they should be the plaintiff here rather than AOC. But why can't they say it's illegal? And I cannot pay money contrary to what the statute requires.
Your Honor, two things on that. First, it does require looking past the reasonable determination reflected in the court's administrative order adopting PTO, that in fact, the judiciary is not providing sick leave. There's not a definition in the two statutes, 10 and 11, that defines what sick leave is. And the purpose of adopting a PTO system is to no longer.
So just by definition, the court can escape the limitations of the statute just by defining it away?
Your Honor, this is in transition and this is the new implementation of the system, but without a definition and a comprehensive scheme from the legislature setting that sick leave shall be granted and defining what it is, setting a rate of accrual and having a more comprehensive system, you have plenty of room for flexibility there. You don't have to find sick leave here. The secretary went to find sick leave.
Wait, Mr. Baker, wait. What you're saying is that the legislature could in fact say that the entire government is actually going to grant sick leave, and that would change the analysis here. Doesn't that go contrary to your argument that the different three branches can do whatever they want, basically?
No, Your Honor, in this sense. I cited the Galinsky case from the Ninth Circuit, where you start out with a determination as to whether there is a conflict that the executive correctly found between the judicial determination of what's policy and what's going to govern its employees.
Yeah, but that case is completely different. I mean, the feds have done some very strange things. They forced all employee issues to be done through this weird little setup that they have internal to the feds, and Congress said, that's great. So it's pretty tough for the executive in that instance to say, no, you can't do it. But it's their own internal system. There's no appeal from it. There's nothing. There's no oversight by anybody. So the landscape doesn't really help us here, I don't think. I mean, you cannot say, and I hope you're not saying that a legislature cannot, in fact, enact a statute which says this is all you're going to pay for sick leave, period in a sentence. This is all you're going to pay for annual leave, period in a sentence. Are you saying that the legislature could not do that and enforce it against the courts?
Your Honor, I think that presents a much tougher constitutional question if you had what I had described. And the reason that I mentioned the comprehensive framework.
That's where your argument's going. I think that's the basis of your argument. In point of fact, there comes a point at which you say the courts, because they're a third branch, because they're an independent branch, because of separation of powers, the courts can do what they want in this regard. The legislature cannot prevent us doing what we want. And I think that's wrong. I hope you're not going that far. Tell me you're not going that far.
Your Honor, what I'm pointing to is the language from Maurer that goes that direction. And in that circumstance, if you have a direct conflict between statute and judicial policy reflected in a court order, at that point, then you would get into the harder separation of powers analysis. But it is in no way a foregone conclusion that the legislature comes out on top of that, because they still maintain the power of the purse. And the power of the purse is the ultimate check. So they're in a defined box. They're only spending money that's been appropriated to them. And if you look at Maurer and its discussion of the placement in the executive branch.
10.7.8, 10.7.10, and 10.7.11 are very general. All state employees, it says. All state employees. That would cover the judiciary, would it not? Say yes. That would cover the judiciary. You're not going to tell me that judicial employees are not state employees.
Let me ask you,
No, I'm saying, Your Honor, that the secretary had to go find sick leave where there was none. And in that circumstance, you would have to say that the legislature said, you as the judiciary must do X with your employees. There's a very serious constitutional question in that.
That's not what they're doing. What they're doing is saying, this is the amount of money you can spend on your employees. That's different. If the power of the purse means anything, it's that the legislature can say, this is how much you're going to spend on your employees.
But it has done that in House Bill 2 every session.
so let me ask you a
Yes.
question. It seems to me that this really shouldn't be a battle with the executive branch. They have no stake in this. They're just a proxy for what they think the legislature intended. The question is whether the legislature has spoken to this. Now, you could say that 10, 7, 10, and 11 is what the legislature intended along the lines argued, but this program began like a year and a half ago, something like that. And we had a legislative session, 2024. I'm not aware, and correct me if I'm wrong, I'm not aware that the legislature said anything about the judiciary's use of this program. They didn't say, no, you can't do it. They didn't put a rider in the appropriation bill that says not a dime can be spent on the PTO program. They said nothing. And they have an opportunity to speak at this next legislative session.
That's
So
exactly right.
how should we read that?
Your Honor, I think that you should read that in the context that, but for DFA's intrusion here, the normal dialogue between the branches of government would have continued. And the Administrative Office of the Courts attempted that, and it was only short-circuited when DFA went, got the AG opinion, and at that point said, we're just going to stop. The discussion was, wait till the session. If we can work this all out among the three branches, great. That's how separation of powers is supposed to work. You don't look for fights. You look for cooperation to work out these problems. And if the legislature has something to say about this, that's one thing. But I think it's important for the court to send a message that the executive should be in its lane and should not be looking to read behind a court order and then interpret the legislature's intent in a certainly less than clear circumstance to block a court order.
So does the judiciary, call it PTO, call it what you want, is the judiciary now paying an employee when that employee is absent from work due to illness?
Yes, and it was before under annual leave.
Okay, and how does this not fall squarely within the definition of 1016H2?
1016H2 is a separate statute from 10.7 and 11, and specifically says that no branch of government shall be required to provide sick leave.
But if you do provide sick leave, why do not the provisions of 7 and 11 not apply? 10.7.10 and 10.7.11.
Because these distinctions between the type of leave you're granting matter. Annual leave it can't be, if you've used it for leave, you can't get paid for it, for illness. It's got to be something more than that, because annual leave has been available for people to use for sick leave. There's a variety of leave you could use for illness. But what I'm looking for here is the legislature having spoken that there needed to be sick leave to start with, rather than the secretary going to find it.
But when you give the sick leave, here's my question. I understand you're saying sick leave is not defined in 7 and 10.7.10 and 10.7.11, but it is defined under 1016H2, and under our rules of statutory construction, you look to text and definitions elsewhere for meaning. Why wouldn't this sick leave definition not apply to 10.7.10 and 10.7.11?
Well, both because the purposes of the statutes are very different, and the latter specifically says that sick leave need not apply, not be granted, suggesting that each branch still retains the right to adopt a different system of leave.
It's common meaning. What is sick leave? You're out, you get compensated. Is that what PTO is doing?
PTO is different than that. PTO is saying, we are going to provide you leave regardless of the purpose of you're gone for. That is a different policy. And the judiciary.
Annual leave?
What's that?
It's not annual leave?
It's not annual leave.
So then you can't have a donor policy?
The judicial rules allow for donations still.
PTO, but the legislation limits it to either annual leave or sick leave.
But there's, on page 22 of the petition, we've listed the variety of differences in the way that that leave has been granted. I mean, there's no legislation that allows for for 12 weeks of paid parental leave, and that's been granted.
Council, can you
Um,
explain for me, coming to the numbers that established the PTO, did they include a set number for annual leave and for sick leave to arrive at those figures? How were those amounts arrived at?
The accrual rates, the accrual rates aren't set in statute for either sick leave or annual leave in any context. And so each branch has always been free to adopt its own accrual
But I'm
rates.
asking you specifically for the judiciary, how were those amounts established?
My understanding that it was adopted as a matter of the judiciary looking at the policy it was adopting and setting an accrual rate. If I'm correct in remembering, the legislature has a wildly divergent accrual rate for annual leave and payouts for annual leave than the judiciary or the executive branch has. So I think when they sat down to do PTO, they were looking to adopt an overarching policy of unified leave. And part of that was setting the accrual rates that are in the judicial policies. So I don't know the specific rates or how they reached those. That's outside my involvement, but that's my understanding of how this came about, is it was a complete review by the court as to the best system of leave to accommodate its employees, recruit them, retain them, and maximize the performance of the judicial branch for the safety.
I'm not sure I understand the conflict that much, because historically, up until this new order, basically the courts would allow the accrual of sick leave unlimited. You could have way more than 600 hours. Annual leave was limited. You could only carry over 240 hours, correct?
I think that's correct.
So when May 31st comes up, DFA has a bucket of sick leave. It could be 600, 1,200 hours, whatever, and annual leave with 240 hours. How do you tap into that old sick leave and pay employees a lot more? They suddenly, overnight, with the stroke of a pen, get twice as much.
So, Your Honor, as this is implemented, I think that creates a tougher issue, because if DFA was authorized to, I think that should have been the administrative office of the court's role to figure out what to do with that. But if DFA, whatever the appropriate person was, you could trace rolled over balances, but anytime you adopt a new leave system, you have to integrate it somehow. Or when you bring employees over from another branch, you have to have a means for doing that. So the fact that old sick leave became part of PTO doesn't mean that PTO is sick leave. I mean, going forward, if the court feels concerned
Why
about
can't the
what,
employee use whatever sick leave they had in the bucket before the Supreme Court order?
they're not
It
prohibited.
was designated as sick leave. Historically, you're retroactively changing the rules.
Right, and I would say that the court should analyze that piece not as dictating, wagging the dog to say as to what PTO means going forward.
And
If
I
you-
might agree with you on
Yeah.
that. As of May 31st, we no longer have sick leave. We have a leave that can be used for a variety of things, including illness or illness of a family member. But retroactively, you still have that bucket of sick leave that you somehow, you're trying to change the rules retroactively. It's kind of like a bonus. Now that you've saved up all this sick leave, we are going to pay you not 50% of anything over 600 hours. We'll pay you your full rate for a certain amount that exceeds.
I'm not sure I would agree with the
Statute.
position if it was a bonus, but I do agree with the
Well,
court
it
that
seems like a bonus.
Right,
All of a sudden, my sick leave has some real value.
one thing I'm sure, Justice Chavez, is that you'll be the one that gets to tell me if it's a bonus or not. But in terms of application, I do think that the court's first and foremost order should be DFA is outside of its lane. From there, it can look at the policy.
Who then gets to challenge the branch's order as being unconstitutional or in violation of the statute?
They should have come into the court.
So you're saying DFA should have,
Yes,
so they should have been the petition.
yes,
Okay, so now we're here.
we're here. But it's still,
So
It still
they
would
still
not
get
have-
to challenge it.
sorry, I didn't mean to interrupt. It would not have involved a unilateral determination by the executive that a court order was unconstitutional. That, I think, is a big separation of powers problem. I'm way over my user
The
time.
issue's the same. No matter who brought it, the issue's the same.
I think the procedure mattered with separation of powers because having the executive blocking orders is a bad practice.
Well, when we analyze this separation of powers issue, this court said in the Clark case, that the test is whether one branch, actions disrupt the, proper balance between the branches. And in that case, this court cites the Nixon case, the United States Supreme Court case, and it says, in determining whether the act disrupts the proper balance between coordinating branches, the proper inquiry focuses on the extent to which the action by one branch prevents another branch from accomplishing its constitutionally assigned functions. So I'm asking you very specifically, how does the legislator's policy decision to limit sick leave payouts prevent the judiciary from accomplishing its constitutionally assigned functions?
Because the court's power of superintending control requires the administration of the courts. And as the 10th Circuit recognized applying New Mexico law at CO, administrative matters related to judicial employees ultimately affect progress of litigation in the court system as much as issues tied directly to specific
It's an
cases.
efficiency argument.
It's an administrative control argument, Your Honor.
How about Constitution? Where do I find that constitutionally assigned function?
The
If I
power
look at
of-
the Constitution, I don't see what you're arguing.
the power of superintending control over the courts. That is assigned to the judiciary.
So the part I'm not understanding regarding this, as I understand the briefing, the sick leave and the 600 hours and the burn it or use it or lose it argument is the judiciary could have just dealt with that by the 240 hours of annual leave. Couldn't the judiciary have just raised that or eliminated that 240 use it or lose it? Use it or lose it did never apply to sick leave. Isn't that correct?
It's
The
a
600
functional practice. Oh, I'm sorry, Your Honor.
No, go ahead.
The functional practice that's the concern is that many employees end up being absent on sick leave a lot when they've accumulated a huge number of hours. And I realize that that's a practical realization, but it's true.
But there was no benefit to burning your sick leave, right? If you started using those 600 hours of sick leave, all you did was diminish the pot that you could be paid from.
My understanding was that sick leave would carry over and you could have a huge sick leave balance.
Yeah.
And then you'd have an employee who functionally was gone, let's say the last 6 months of their employment, whether continuously or sporadically, a sniffle might leave you home.
Report from a doctor, you can't just take 600 hours of sick leave before you retire.
I would say that perhaps employees defined the circumstances under which they were too ill to report for work differently as they approached the loss of hundreds of hours of leave.
But what's the benefit? If I have 700 hours of sick leave, I could only be paid for the 100 in excess of the 600, right?
So you would have earned these extra hours for which
100.
that are just being wiped off,
Well, you'd get paid out at 50% of it.
paid out
So-
50%.
Yeah, but if I'm just burning it, I get nothing. Because let's say I had 20 hours of sick leave. The 700 hours is suddenly 680 hours. So now I'm just being paid out on the 80 hours rather than the full 100.
So I think that many employees would view the benefit of the full wage that they would have received for the course of the day by being out over the value of the payout. But I also think that that's a decision of policy that's embedded in this that should have properly been left to the court when it adopted the PTO policy itself and is outside something that DFA would have any say in for certain.
If it's not sick leave, why does the judiciary still require, could still require a medical note?
Because if somebody's abusing leave of any kind, there has to be a means to check it. And so at some point you have to have some follow-up check system. And so the judiciary isn't saying this isn't leave that can be used for illness, but if somebody is expected to be in work in the dialogue that the policy contemplates between employer and employee about when they're going to be out, if an employer says you need to be here on Tuesday, the employee says, oops, I'm sick, and they find out that they were water skiing, they should be able to ask for a doctor's note. That doesn't mean that it's sick leave bound up in the 1980s statute that had no definition of sick leave when the legislature has said that sick leave is an option, not a requirement.
There are numerous provisions in Chapter 10 define the state or a state agency as including the branches of government. You agree that whenever the word state or state agency appears in the statute, then the courts are included?
Your Honor, in section 10, there's an argument that that is true. It's also true that the legislature specifically has referred to the judiciary when it's wanted to include it in statutes,
Yes.
and has specifically excluded the judiciary entirely from the State Personnel Act, which does reflect a legislative determination.
That it has, but chapter 10 deals with employees.
Chapter 10 does deal
So
with.
it's more relevant. Although retirement, I know they include the judiciary. But let's talk about the legislature. They appropriate funds for all three branches of government, correct?
Correct.
Are you telling us that they do not have the power to develop limits for the appropriation so that they can plan ahead in the future? As an example, had they been told that we have this new policy, the legislature could have addressed it during budget hearings or whatever, or you work with DFA. On the other hand, it seems to me that when it comes to what you've done, what the court has done here now is they are trying for reasons that we don't have to argue about. The wisdom of it is not at issue, but what is at issue, I think, is the power of the legislature to define limits. And so what they've said is you have broad discretion. Any state agency has broad discretion to award sick leave. We don't care how much you award, or you don't even have to award it. But if you do, if you choose to exercise your discretion in favor of leave, here's what the buyback provisions are going to be limited to so that we as a legislature, as we appropriate funds, can know what our risks are in the future. What's wrong with that analysis?
Your Honor, only the very last part, in the sense that no one is arguing that the legislature still has to operate within its appropriated budget here. And the judiciary has generally received more open-ended appropriations than any other branch, in part to guard against mischief that's happened in the past, which would include, I believe, an effort to line item veto Justice Daniels' judicial assistant and to not furnish the new courthouse in the first judicial district. And so there's mischief that can play if you start appropriating line by line for the judiciary. So we're still operating within the framework. They still are dictating the budget. And I suspect that, not to use too technical of legal damage, they will have hell to pay if they're back in front of the session in January. They have blown their budget. But they're operating within their budget. And so that counsels against, especially when there's not a set accrual rate, because if the legislature wanted to dictate for budgetary purposes what the inputs and outputs would be, then you could control what the money was going to look like. But just capping the buyback doesn't control the budget because the multiplier on the front end can be significantly higher. So it doesn't read like a real control. And I would expect the legislature to speak with more clarity if it was seeking to dictate.
Well,
Because the judicial is
with these provisions in place, it's easy for any state agency to know who is up for retirement, how soon will they be up for retirement, and what is the status of their sick leave. Do they have thousands of hours or do they have less than 600 hours? That makes budgeting a lot easier.
And the AOC will have to report that under the PTO policy to the legislature in hearings that are ongoing. The dialogue with the legislature has not been interrupted by this. It's ongoing. It's been disrupted and forced into court in a litigated posture because DFA intervened. But there's a lot that the legislature can speak to on this, and the judiciary is going to have to deal with that and accommodate the mutual concerns of both branches come January.
And
But
counsel, in fact, if we were to say, hypothetically, if we were to say it's not clear from the statutes that the judiciary cannot do this. So we issue the writ and say, as a matter of, because of the absence of any prohibition, clear prohibition, you can go ahead and do this program. But the legislature, when it convenes in January, and they consider next year's appropriation, they have many ways to contradict that, don't they?
they do.
They could pass a statute amending 10.7, 10, and 11. They could put a rider on an appropriation bill saying not one dime of this shall be spent for PTO. Then we would have a separation of powers issue. And you folks would be back in front of us again in the spring if they were to do that. Or the legislature could just let it go. Appropriate the money, PTO continue. And we don't have to decide the constitutional issue.
And Your Honor, the separation of powers issue that you would have before you in that circumstance would be the appropriate separation of powers argument between the legislature and the judiciary, rather than the executive reaching in to look behind the order and create the problem that we're here about. I'm way over my time.
Thank
I
you, Counsel.
apologize. I hope I didn't.
All right, thank
use my
you.
privilege.
One last question.
Yes.
Go ahead.
One last question. Well, two last questions, I'm sorry. One, the legislature in January coming up could pass a statute saying, we recognize the courts have done this new thing with their time off, but we're not going to let them pay more than anything above 400 hours, period of sentence. It's going to cap. So that would create, as Justice Boston has said, a straight up separation of powers issue, I suppose. I want to ask you to tell me whether you think the legislature is going to do that. But back from that, what that really means is that this case right here, if we want to avoid a separation of powers problem, the basic question is, do 10, 7, 10, and 11, do they apply to the legislature and I mean to the courts, and are they do they limit the amount of money that can be paid by the courts for accumulated time? That's the basic issue, right? It's a statutory interpretation issue.
I don't believe so, Your Honor. I believe it's first and foremost an executive action intrusion into the judiciary question, followed by, if you find a conflict there, separation of powers problem between 10 and 11 here. But I think the executive overreach issue is in many ways paramount because it did force this into the posture it was in and upended a judicial policy for at least 6 months until we could get in front of the court to get it resolved.
But that gets us nowhere, though. I mean, if we say there's separation of powers, yeah, DFA should not have done what it did, yada yada yada. And we get rid of it. Then DFA files its own petition for mandamus or a declaratory action here, and then we're back in the same place, arguing exactly the same things. Nobody wants to do that.
I'm not saying that from a practical standpoint it changes things, but from a preservation of judicial authority, it's an important principle. Because the idea that you have the executive looking behind orders to determine for itself the legality of a policy is problematic.
You keep saying intrusion, that is separation of powers. I'm sorry.
No, do you have a question?
Yes, I do have a question. Obviously, if it's ministerial, great issues. When you look at the duties of the secretary under 9-65 of the Secretary of DFA, it says that the Secretary of DFA administers and enforces the laws with which the department is charged. And it seems to me that implicit in enforcement is ensuring compliance. You have to examine what the branch is doing or the agency is doing and exercise your judgment where appropriate as to whether whatever has been submitted for payment is proper within the law. Help me explain in light of, help me understand in light of 965A that says they have to administer and enforce the laws, how what the secretary did is just simply ministerial. We gave it to you, just pay it. I feel like that's what you're saying in your brief. You got it, just pay it. But that's not what the statute says.
Your Honor, the statute would deal with DFA's authority over executive branch agencies. The statutes that it's in charge with are separate from the ones that are separately delineated for the administrative office of the courts in 34(9)(2) and 3, which include authority over employees, supervising the administration of the courts, and handling all problems of finance within the judiciary. DFA really is here only because it houses the share system. I mean, I'm not trying to oversimplify it, but I think that's really true. That the only reason DFA deals with judicial or legislative employees at all is to avoid replicating and creating redundancies in the physical process of cutting a check. In the ERB versus Romero case we cited, recognize that oftentimes DFA is required to process payments over which it has no approval authority. And that was within the executive branch, albeit constitutionally protected, but ERB is entitled to set its own salaries for its own employees constitutionally, and DFA tried to overreach and do that. And the Court of Appeals, which was not sought, review before this court was not sought, said, the statute's allowing you to oversee this, to oversee finances generally in the state. Don't reach into ERB because it is its own body. And now we're dealing with a co-equal branch of government. And having, just as if OPM was deciding that the judiciary got it wrong in providing same-sex benefits for healthcare, as required under the judiciary's anti-discrimination policies, so too here DFA is saying, I know you said you're not doing annual leave or sick leave anymore, but we're going to go find PTO and cap it. And I think that that is where they've gone too far.
So under your analysis, then the judiciary could just set up its own share type program. And then what would happen? The legislature would just deposit the money in the judiciary's bank account and we operate our own share account?
It would be wildly inefficient. And that's the reason the DFA has a ministerial role in the other employee over getting checks to other employees of government.
But that doesn't answer the question. I mean, you know, if it was a bigger state like Texas or California, and it was efficient to do it that way, isn't that the result that you're advocating?
Set up your own bank account, judiciary will put the money there, operate your own system. Isn't that at the end of the day, a true separation of powers, which all our cases say can never be achieved? Wouldn't that really be what would have to happen?
And I'm not advocating for that, Your Honor.
Okay.
I'm saying that that you should take into consideration the fact that the only reason DFA has a role here is to implement with judicial and legislative employees, to implement the instructions given by the administrative apparatus assigned to those two bodies, separate bodies of the government.
If the money's appropriated, DFA has no discretion. They must honor as long as the request is within the appropriation. Lee
Yes.
versus Hartman.
What's that?
Lee versus Hartman?
Yes.
Thank you, counsel. Counsel, if you need more time, you're certainly entitled to it.
Thank you, Your Honor. I'm beginning to be concerned I didn't bring my lunch. The court. I'd like to take just a little bit of my time to address a discretionary point with the court, and that is whether mandamus is an appropriate remedy in this case, and then turn to the more meaty question of the merits. As the court's aware and counsel has been discussing, the legislature is interested in this matter, aware of it, and about to convene. There's every good reason, because the legislature can avert any constitutional crisis here in any number of ways, one of which being to delegate power to the judiciary to deal with this issue as the judiciary sees fit. Another would be to amend the buyback statutes, 10-7, 10 and 11, and probably there are other ways. And the way separation of powers problems should be worked out is through the political process. That's the way they're traditionally dealt with. And it's the way government trundles along and manages to function with shared powers among the branches, cooperation, balance, common sense, and reason. So I'm advocating first that the court stay its hand and see if the legislature can resolve this matter. And I'd offer a second reason why the court should defer any action on mandamus or deny mandamus on a prudential basis. And that is that the worst case scenario here is that the judiciary branch employees who are seeking to monetize their excess leave are going to have to wait some time before the process works out judicially and they can collect the leave they desire to sell back to the state. Compare that to cases where mandamus relief has been granted on monetary matters. For instance, cases in which what was at issue was employment benefits or welfare benefits. The judicial employees here have jobs. They're either transferring out of the judiciary or they're about to retire and they're looking to collect money. They're not anywhere situated similarly to welfare recipients or unemployment recipients. Uncertainty and delay are just a part of resolving disputes that find their way into the legal system. This is one of those cases. It's not a situation where the court's immediate action through a writ of mandamus is demanded. The alternative, allowing the judicial system to work from the ground up, declaratory judgment action, discovery, development of a factual record, lower court opinions, ultimately, if needed, an opinion by this court, is a perfectly adequate way of resolving this controversy. And if money is owed to the recipients who want it, they will get it.
Is it realistic? But is that really realistic? Isn't what's really going to happen down below district court is every judge that gets it below is going to look at it and say AOC, Supreme Court, and refuse. Is that what's going to happen? So it might as well just start here.
Well, I would expect, Your Honor, that the courts would recognize that it's not workable for every judge to recuse, and there is the rule of necessity, and someone will decide, and it will move on through the system, and eventually, if it needs to, reach here.
Well, the real issue of concern for me is that are there any factual disputes that need to be resolved? That the lower court would need to resolve those before we reach a decision here?
I'm sorry, Your Honor, I didn't quite hear that.
Are there any factual dispute? Is there a dispute about the facts that we would need a district court to have a hearing about the facts?
Yes, well, I think, we sort of know the facts. I probably least of all because I'm in the least involved. The process of litigation from the lower court up allows a factual record to be developed. And to the extent things might matter to the decision, for instance, what is the fiscal impact of the PTO plan versus the statutory plan? We don't have a record addressing those issues. So I don't want to spend a lot of my time on this. It's secondary to the merits, perhaps, though it's a way to avoid the merits. But I do want the court please to consider that in its discretion, certainly the billing action is writ is not is far from imprudent. Let's put it that way. But turning to the merits, the petition should be denied because there's no separation of powers violation here. In New Mexico, the separation of powers analysis that this court's used for decades, at least since Maurer, recognizes that there is no precise line of separation, that the law tolerates some overlap of function, that common sense and cooperation are the way that government functions, and that the idea of absolute borders, which is something that I think is close to what the petitioner is arguing here, that the legislature cannot touch actions by the court relating to its personnel. Absolute line drawing like that is not favored and not workable. When this court has mapped out the overlapping functions of the judiciary and the legislature, and maybe I should add, as we see it, the department, the secretary, are doing what the executive branch is supposed to do, seeing to it that the laws are carried out.
But their position, petitioner's position is this is just a matter of convenience because the judiciary doesn't have its own share system. Can you address that?
I'm not sure. I think what this is a matter of the department recognizing that there is a question here of the PTO plan versus the statute. And the point I simply wanted to make there was, I think the fundamental separation issue here is legislature and judiciary, not administration, executive and judiciary. But
for 14 months, DFA was able to accommodate the PTO policy.
it seems that, and again, we don't have a factual record that clarifies this, but for a time, the DFA was administering the plan as best it could. And I understand there were difficulties with making it function and working this shared system
That's why we have humans to help.
Yes, but for whatever reason, DFA actually sought to execute and carry out the laws, asked the Department of Justice for an opinion on what to do here, and got an opinion, and is complying with that opinion. But I do think that the target here is not the DFA, which is simply doing what it believes it should do in executing the law. It's whether the legislature has the power to impose sections 10 and 11 on the judiciary, or whether the judiciary is so independent that it may adopt its own employee benefits plan that has no constraint from the legislature, except that it fits within the pot of money generally allocated by the legislature.
Why shouldn't we wait for the legislature to speak? They had an opportunity to speak last spring, they didn't. They're going to have a big opportunity now coming up. They can express their pleasure or displeasure as they see fit. That might provoke a separation of powers issue, might not. We can avoid that for now. We just order the DFA to return to the status quo and then wait for the legislature to speak. Wouldn't that be the best way to avoid conflict for now? And give the legislature a chance to speak. I know, for example, the legislature did not seek to intervene in this case. I read in the newspaper, there was some discussion of it, but I don't know the facts of that, but they're not here. They could have filed an amicus brief. They're not here. So for all we know, the legislature's just fine and content with the status quo. We just don't know.
I think, Your Honor, you're close to what I was advocating a few moments ago, which is the court really ought to be waiting for the legislatures to take the opportunity, if it will, in the upcoming session, to address this matter and hopefully resolve it. I don't think that entails ordering the department to maintain the status quo. I think that simply entails the court awaiting further clue what the legislative intent is, and not compelling what appears to be a direct violation of the statute by the judicial branch in the meantime.
So then the legislature adds the definition of sick leave to chapter 10 or article 10, where there is no definition, or they double down, then we're just back here at some point on the separations of powers issue.
Well, if the legislature, the legislature can cure the problem in ways, that I probably can't even think of, as well as simply repealing the statutes that the DFA is treating as blocking the PTO plan, or amending them in some way, or passing other legislation that addresses the problem. There are any number of ways that can happen. And we at least know this. There was a session of the Court's Corrections and Justice Committee just weeks ago in which both the department and the administrative office presented to the committee on the PTO plan. So something is at least of interest there. Both parties received letters from Senators George Munoz and Joseph Cervantes before that committee session. Both letters indicating they wanted information and the legislature was interested in acting. I guess all I'm saying is we don't have a record here that explains this in depth. We don't know what the legislature's thinking, but until the legislature's had an opportunity to address the situation as it's boiled up now, I think the court should prudently stay its hand. And yes, the legislature, this program was in existence the last time the legislature convened for a short session, but I don't believe that any of this controversy was really in play at that time, and there was no reason for the legislature to focus on it, and therefore not much meaning that can be drawn from legislative silence in that regard.
So if the court took the option of waiting for the legislature to act, then what happens? Status quo?
What happens is, status quo as of the present. Yes, I believe that's what happens. And, you see what the legislature.
But the new system's not in place. The new PTO system would not be in place.
Yes, it would not be in place in, at least with respect to operating on the buyback basis. It would operate under the statutes. And that is, it would be limited in payback and buyback to what the statutes would permit, not the extra sums that the PTO plan itself.
Well, even if we chose to speak and say, no DFA, allow the PTO program to continue pending what the legislature says. We can either return to the status quo or we can say nothing. Either way, the legislature is going to speak, I suspect, and they'll let us know what they think. They can say, for example, here's your appropriation, judiciary, not one dime should we spend on PTO. That's a pretty clear expression of intent. And then council, if they chose, AOC, if it chose, can bring this issue back for a real separation of powers question that we then would have to decide. Something we don't necessarily have to decide now.
Well, yes, I think we're just agreeing with each other, except perhaps for a hair, Your Honor. And
Well, it's a little more than a hair.
all right,
Because we could just do nothing, in which case PTA would not exist. Or we could tell DFA, no, return to the status quo before you took this action. And PTO would continue unless and until the legislature expressed its intention that it will not fund it. It will not fund PTO. Then at least we know where they stand. And then we have a separation of powers issue. We'll all come back here in the spring and decide. We're still around.
Of course, I think Justice Blossom's suggestion would be a real challenge. I mean, the legislature actually say we're not going to fund PTO. That would run into all kinds of problems. I mean, that's a doomsday sort of scenario, which would truly precipitate a separation of powers crisis, I think. But if the legislature did something short of that, like say, you can have your PTO system, but you shall not pay out more than 400 hours worth of time, no matter how much the employee has in place. That seems to me to be exactly the same situation we have currently, assuming 1010 or 710 and 711 apply, and so that doesn't change the analysis in any way. It doesn't change the problem in any way at all. You have the same issue, and you probably have this, and you'd have the same. What it would change was you'd have the AOC as the plaintiff again, and they would be able to say that DFA stepped out of line because it's the legislature that imposed it on them. So I don't know. I don't know that staying our hands really gets us anywhere in terms of the real issue. If you want a real discussion of this issue, we do it now or we do it later. It's going to be the same. I don't see an advantage in some ways, except that if the legislature acts, it's a clearer problem.
There seem to be legitimate management issues in front of us. AOC has decided, for a variety of reasons, I suppose, to have a PTO policy and to increase the buyback. It could very well be that because the judiciary employees in comparable positions are paid about 10% less than executive branch employees. It could be because the private bar likes to steal our employees after they've been fully trained. And maybe they need to make it more attractive for them to remain with the judiciary instead of leaving to the executive or leaving to the private arena. That seems to me to be a judiciary decision to be made, not a legislative. Wouldn't you agree with that?
I'm not sure, Your Honor, that I track the.
Courts manage employees. Courts decide how much to pay employees. As long as they do it within the appropriation, legislature shouldn't be complaining.
that there is no fiscal impact.
There is no fiscal impact.
Well, that's certainly a point that's been made repeatedly in the petition and in the argument today. And I think I can combine an answer to that with a thought I was going to add to my response to Justice Bosson, and that is, if we're contemplating waiting for the legislature to speak because the situation is unclear as to what the legislature thinks, I would point out legislature has spoken. The legislature has spoken through sections 10, 7, 10, and 11, which relate to the buyback of sick leave from all state employees. And those statutes are as much part of the appropriations process, in our view, as an appropriations bill would be. That is, they are part of the legislature's exclusive power, as this court has said, to determine how, when, and for what purpose public funds shall be expended. And what the legislature has said is a broad policy matter, not even targeted. And targeting is questionable as a separation of powers matter, but not just targeted at PTO, but has said it as a broad policy position that money is not to be expended, public money, on sick leave in excess of so many hours.
But if you're right, counsel, why didn't the legislature say so last session? They funded the PTO program, knowing what it was, knowing that it was there, knowing that it was in place. They funded it last time without any restrictions whatsoever. It wasn't until the DFA injected itself into this process that we even had a problem. It seems to me you could interpret what has happened in the past. Haven't they already spoken?
Well, I think between the legislature having spoken in a statute on the books and having not said anything in its last session, legislative silence is an awfully tenuous basis on which to determine legislative.
It's not total silence. They funded it. The money's there, right? The appropriation is there.
But if I may answer just for a second, they funded it, but in the context of sections 10 and 11 being on the books.
But we don't know that. And what PTO does is it does away with sick leave. And so they're saying we're not giving sick leave.
PTO does away with sick leave and throws everything into a bucket that can't be differentiated, which is actually another reason why it's a separation of powers violation, because it makes it impossible for the DFA to administer or the legislature to have any meaningful effect out of sections 10 and 11, which relate to sick leave. If you can't find the green marbles in the bucket with the blue marbles because, they all look the same in the dark, you can't administer the marble sorting program.
But
It's the same problem here.
AOC is saying we're staying within our budget. We're not exceeding the budget. So that allows the legislature to know and be able to plan, and allows the judiciary as well. So it seems like, first of all, PTO system did away with sick leave, and the judiciary stayed within their budget. So they let it go along. And at some time, AOC discovers, the judiciary discovers, this is costing more money, and we're going to have to go in and ask for more money. Is that a better time to wait?
Well, I think a factual record would help here. What I've been told is that the experience of DFA within the months that the program was operating was that there was something on the order of $1 million of extra expenditure. Maybe so. I can't cite you to the record because there is none. But I think there is a serious question of fiscal impact here that would make the legislature interested.
Is there any information you have that they've exceeded their appropriation, of course, by using this PTO program?
I do not. I would certainly take our friends there at their word that they have not exceeded their appropriation.
Well,
But-
the Hartman case says the DFA has no discretion as long as what is being requested by the agency, or in this case, the courts, fits within the appropriation.
I believe that's their argument and
Isn't that what Hartman holds?
I think what the law is or should be is that the DFA can't expend money contrary to a statute by the legislature relating to the expenditure of money. That's the legislature's.
Of course, the difficulty is with DFA making that decision. It's,
Well, the DFA happens to be, holding the checkbook. So they made the decision in that respect.
right, and they've been told by case law that as long as what the agency has requested is within their appropriation, then you pay it out.
Well, Your Honor, I don't think the case law goes that far. I think that the case law is very case specific to the specific statutory or constitutional schemes that establish the entities in question and how DFA's authority relates to them. And in this case, DFA's authority relates to the administrative office in that DFA is required to comply with statutory law relating to the payment or buyback of sick leave. And that's what it's attempting to do.
I'm struggling with the going retroactively. At least I perceive it as maybe being retroactive, changing what existed prior to the order into now PTO, which changes its value. But moving forward, I'm not sure I see the problem because the only question that arises that impacts fiscally is the point of separation, either transferring into the legislative branch or the executive branch or retiring. We know at that point, it's not sick leave. It's PTO. It's basically annual leave. So it's not controlled by the statute.
If the statute only applies to sick leave and leave is taken out of the reach of the statute by being called PTO, that is correct, Your Honor. But it seems to me that would be turning a blind eye to the obvious intent of the legislature.
Well, you're looking at the point of separation. You're not looking during employment. Because I do see the difference. If I'm sick, I get to take my PTO. Well, that's because you're sick. So that's sick, right? But when you're separating, you're not interested in taking time off from work. You're retiring. Or you're transferring to another department and there are separate rules for that.
Well, I think the way the legislature could view the situation is, sick leave is time that, or payment for, let me put it this way, payment for accrued leave is payment for time the employee would not be anticipated working. And so it's effectively payment for not working. And that's why the legislature, I think, would view that is an area of concern, an area where it would want to exercise some control in its role as the fiscal, as exercising the fiscal authority for the government of the state. Not sure I'm hitting precisely on your question, Your Honor, but the idea that sick leave is somehow merged into PTO, I don't see how that can take it out of the reach of a statute just because the statute only relates.
The law seems to be that the courts or any state agency can decide not to award sick leave, period. Do you agree with that?
I do. That is the law.
So the courts could basically have said there's no longer sick leave, there's annual leave.
Well, but the courts have defined PTO to embrace sick leave and other personal leave. So, I mean, it's right there in the plan, in the glossary.
Can I clarify an earlier answer? Are you stipulating or you're agreeing that in fact the judiciary is not exceeding its budget, or is fact finding needed here?
Am I agreeing that judiciary is?
Is not exceeding its budget with this new plan?
I have no reason to doubt what is said by the other side. I just have no information.
So you
Either
accept
way.
that fact is true?
But I'll take it as true for purposes of argument, and I have no reason to think counsel would misrepresent. And in fact, I'm sure they would not. If I could spend a minute on the supplemental authority that was cited, because I didn't have a chance to
Just
submit a
keep it
response.
as briefly as you can. Yes.
I appreciate the indulgence. That supplemental authority is a strange beast, as Judge Bustamante observed. It's not judicial authority at all. And so I would suggest to the court that it look at the history past and subsequent, the one that was cited. The authority that was cited was Judge Alex Kaczynski, sitting as Chief Judge of the Ninth Circuit, in an administrative capacity, ruling on a personnel matter raised by a complaint or whatever it's called, by a staff attorney working for the Ninth Circuit, whose child was denied health benefits because the attorney was in a same-sex relationship. And she thought that was unlawful. And that went, because this is the way the Ninth Circuit and the federal judiciary is set up, that went to Judge Kaczynski as the chief judge, not sitting as a judge, but sitting as a hearing officer to decide what to do under the benefits plan and remedial scheme that governed those federal benefits. And that's the decision that was cited to you. The history there is that before this happened, for the decision that was cited, Judge Kaczynski issued an earlier decision in which he said, he interpreted the federal benefit statute as allowing benefits to the staff attorney's child. The administrative office of the court, of the federal courts, didn't comply. Judge Kaczynski then ordered them to. They did comply, but it hung up with the Office of Personnel Management of the federal government, which didn't comply. On that occasion, the opinion that was cited to the court, the decision, whatever it is, the Office of Personnel Management didn't comply. And then the staff attorney filed a mandamus action, of all things, in federal district court. So finally, we're getting to a judicial view of separation of powers in a very similar context to this one. And a federal district judge ruled against the petitioner on mandamus. I'm going to say, by way of a spoiler, the staff attorney got her benefits another way. But on mandamus, she did not succeed. And what the federal judge there wrote in denying the writ was this, and forgive me for reading, but I didn't have time to write a response. The orders issued in this case, in which plaintiffs seek compliance by writ of mandamus, were issued by Judge Kaczynski, not sitting as the chief judge of the Ninth Circuit in his Article 3 capacity, but rather as an administrative hearing officer. As such, the court has not found any authority to support the proposition that such administrative orders can bind the OPM in its administration of the federal benefits program. Although the separation of powers doctrine does afford courts structural independence in their core judicial function of adjudicating cases or controversies, there is no similar authority for the proposition that the independence of the judiciary applies to the administration of the court's personnel system. That's subsequent history of the case. It's hard to find because it jumped from an administrative to a judicial forum, but it's at 781 F supplement 2nd 967. In this case, the court, in adopting the PTO program, was really not acting in a judicial capacity. It was acting as the administrator of the court system. It's very similar to, very similar to what the federal judge confronted in the case that we find as part of the history of the supplemental authority. So I'm well over my time. I thank the court for the extra time. I don't believe a case has been made out for writ of mandamus in this case. And so that's the reading.
Thank you. Counsel? Can you redirect?
So let me just start by acknowledging that I told Mr. Ricco that it's nerve-wracking arguing with him because he's a well-known quantity in this case, and I will eat crow on the subsequent district court decision that I missed in the Galinsky matter. But I do think that it ties back to case law, including Musk. I picked a poor vehicle to make the point to the extent that the district court disagreed with Judge Kaczynski in the Ninth Circuit matter. And the point being that when a coordinate branch sees an order from this court, it should not assume that it disregarded here specifically sections 10, 7, 10, and 11 in adopting PTO, and instead adopted an order that conformed with that before it would issue an administrative order adopting that for the judiciary. This is, after all, the branch of government that decides what the law is. In terms of some of the practical questions that have come up, and I realize that there are sticky issues here, but I just want to reiterate that many of these never would have arisen but for DFA short-circuiting the dialogue between the legislature and the judiciary. Had this rolled through another legislative cycle, we would have seen either that consistent with what they did when they appropriated last year, they had no problem with this and agreed that the legislature in adopting paid time off was not intruding on 10, 7, 10, or 11 and had the authority to operate so long as it stayed within its budget.
When you say the legislature had no problem with this, was there discussion during an open budget hearing, or where did they say that they do not object to PTO, or is it acquiescence by silence?
I'm taking the point that Justice Bosson made, that they've had opportunities to step in if they felt as fervently as DFA did in blocking the order. And if that dialogue continued between the judiciary and the legislature, I think there's a very high likelihood that we would never be here, because there are very few circumstances where flashpoints have to arise between the government that require judicial intervention. And I do think that the point—
Are you agreeing with Mr. Ricco that we ought to put the brakes on?
I'm agreeing with Justice Bosson that an appropriate consideration might be to, in order to avoid future circumstances like this, where a very messy, complicated problem gets boiled over by executive intervention in a judicial policy, that the court should issue a writ recognizing that, consistent with Hartman and Musk and other decisions from this court, DFA has overstepped. And then, to the extent the legislature is going to speak on this, it's going to speak on it. And I think there's a very high likelihood that the judiciary and the legislature work that out. But this got forced into a very contentious posture by DFA stepping in last June after 14 months and unilaterally blocking.
How would the writ read?
What's that?
How would the writ read?
The writ, I think, would read that the court finds that, consistent with Hartman and Maurer v. Rusk, DFA secretary shall cease blocking implementation of the court's paid time off order, and then leave it for, to the extent there ever has to be future litigation, the appropriate party to bring the matter back into court if, following the legislative session, there's additional action. But I do think that that first part is necessary, because I don't think the court should let sit this executive move into the judicial branch.
You said cease implementation. Did you mean?
I mean, cease obstructing implementation.
So you want a mandamus, you want us to mandate that they adhere to the PTO policy?
Pending.
That's what you want?
Yes.
So, okay, what happens if the legislature disagrees? Is there the refunds to the legislature? What happens?
If the legislature disagrees, then the legislature will act. And at that point, the court will be faced with whatever the natural decision by the legislature would be. The courts will first be faced by that as a co-equal branch and deciding whether they are willing to abide by where the legislature comes down on that following a 60-day session. And then to the extent that, that my client determines that that creates a separation of powers problem, or if there's future fallout from it that requires a dispute to be resolved, there could be a case that's framed then under a clear understanding of the legislature's reaction to what the judiciary clearly believed was an order that was within its authority to adopt.
Can I ask you, in your briefing, you spent a lot of time talking about the variety of leave between the three branches.
Yes.
As I understand it, both the legislature and executive are complying with the statute in the 600-hour buyout. Is that correct?
I don't know. I haven't specifically confirmed that. I know the legislature has wildly divergent accrual and payout for annual, but I don't know about.
I saw that and somebody, we were provided a policy as one of the exhibits that had the
Yes.
600 hours built in it, whichever branch it was. So let me ask you, if the court grants the writ, with respect to the separation of powers issue, it's just not a separation of powers issue that implicates the judiciary, right? The other branches could, the executive could say, well, this is a legislative enactment. It doesn't apply to us, so we're not going to abide by the legislative enactment either. Isn't that right?
The legislature could,
The executive, I mean, the executive is trying to comply with the law, DFA, right? They're trying to comply with the statute or with the 600-hour buyout. If the writ is granted, the executive could also set its own PTO policy.
it could, and then the appropriate party could challenge it. If
Sure.
they believed it completely.
Legislature, exactly. So it sort of renders the statute moot at that point.
Only if you believe that it so clearly prohibits this and separation of powers allows it. But you'd still have to, the question of why is DFA in this lane? And that I think is the center post. And I realize that I keep hitting that point, but I do think it's an important one because it's an intrusion into a co-equal branch. It is not DFA's purpose when there's the administrative office of the courts and the court overseeing it, or the legislative council service and the legislature overseeing it, to assume a supervisory role over all matters of finance across all three branches of government. And because I've used so much time answering the litany of questions that came before, I'm happy to cede my time.
Let me make sure that I understand your point about DFA. I mean, DFA is charged with administering all of these statutes, correct? And DFA apparently came to the conclusion after talking to the AG's office that 10 and 11 controlled and the PTO was contrary to it. And so your problem is not with their decision, but how they proceeded. They should not have refused to comply with PTO or pay out in accordance with PTO. If they really felt strongly about it, that it was illegal, that they should have brought a case in the courts for statutory action, I suppose, is what they would offer. And if they had done that, then there would be no issue for other than the statutory interpretation issue. Is that your point?
Yes, Your Honor, if that's the appropriate way for the executive. The executive also could have gone to the legislature, and they've been vigorously raising their concerns about this in the interim committee meetings. And the legislature, they could pick either branch to seek a remedy from this if they thought it was really a problem. But instead, they took it upon themselves to block the order. And I think that requires a remedy. And that's why we're asking the court to issue a writ of mandamus. We think overall the PTO order is sound. We think that the dialogue with the legislature should continue without the interference of the executive branch. And we'd ask that the court issue a writ accordingly.
So it's improper even if they're right.
For them to unilaterally block it, yes. For the executive.
Even if they're absolutely correct, it was improper for them to do what they did.
Yes.
Thank you, Counsel.
Thank you all very much.
The court will now stand in recess. We will retire to confer, and if possible, we will return and announce our decision. We ask that you remain close at hand, available, and we'll let the clerk know when we're ready to issue a decision. So the court will stand in recess. Please be seated. Thank you for waiting and your attendance. The court has come to a unanimous disposition of the matter, which I'll read to you. It's very brief and attempt to summarize our discussions. Don't hold me to every word. We will issue an order today if we can. There's not complete unanimity among members of the court on various aspects of this case. It's a challenging case. Anytime you involve the two branches of government, much less three branches of government, all in the same case, discretion and respect for the Constitution dictates that one proceed cautiously and carefully. And we want to do so in this case. Every separation of powers case that our Supreme Court has written and other courts have written all begin with the same place, that you should avoid deciding a separation of powers case if you can find another way, out of respect for the other branches of government. And we want to demonstrate that respect today. By what we proceed to do. We regard a decision on the separation of powers issues, for example, as premature. There are things that could be done in the future. Out of respect for another branch of government, we want to give the legislature an opportunity to address this, however it chooses to do. And we hope that the legislature would be mindful of the potential separation of powers issues if they were to go in a certain direction. Let's just put it that way. But they have not had an opportunity to clearly address this. One can read what they did or didn't do a session ago, but that's somewhat perilous, trying to draw much of a presumption from silence. This will not be silence unless the legislature, knowing the issues at stake, choose not to address it. I see representatives of the legislature in the audience. I'm sure this message will get back to the appropriate parties at the appropriate time. Meantime, pending what the legislature does, we have to decide what to do with this specific case. And we have decided unanimously to stay the present proceedings pending the legislature addressing this, and give all parties a chance to try to achieve a resolution that is agreeable to all parties, though not necessarily everything they want. And I mean by that, the two principal parties, the legislature and the judiciary, and the executive, to the extent that they see a role in these proceedings. And so it is up to the parties to take it from here with the legislative session pending. The only question then is, when the legislature speaks, then it will probably be up to petitioner, in this case, the AOC, to bring it back to this court if they decide to do so. The only question then remaining is, what is the status quo pending the legislature addressing this and pending perhaps this court getting involved again? The court has agreed, not without some discussion, but the court has agreed unanimously that that the status quo at present time will remain up until the legislature addresses this and the court gets involved. That means that for the present time, the PTO program is on hold. And the DFA disposition of that exists during the next 2 or 3 months until the legislature addresses them. We really do encourage the legislature and the judiciary to address this seriously, at length, and with respect for each other's powers. Because anytime the court gets involved in addressing that and drawing a line, somebody gets hurt by that, somebody doesn't. And we try to avoid that, again, as I said, out of respect for the other two branches of government. So that is what our writ will say, perhaps a little bit more abbreviated fashion, hopefully, than my ramblings. Do the parties have any questions? If not, then the court stands adjourned. Thank you very much.